Good morning. My name is David Padilla, and I've been invited by Naomi Kinsella of the ABA ROLI program to come and talk to you today about the Inter-American Human Rights System. I'm a lawyer, I'm a U.S. national, and I currently teach at the University of Pretoria in South Africa and also at Silliman University in the Philippines. And I teach human rights law. In the last few years, I've become somewhat of a student of ASEAN and the ASEAN Intergovernmental Human Rights Commission and the work that's going on regarding an ASEAN Declaration of Human Rights. Naomi has asked me to talk to you this morning for a while, and in a few days there's going to be a question and answer period. So I look forward to that, an exchange by Skype. But I hope this filmed presentation is useful for you. Naomi has asked me to answer the following question. She says, what does a human rights system need for it to function effectively? Okay. In order to answer that question, I have to tell you the story about the development and the evolution of the Inter-American system. And I think you'll see a lot of parallels with what we in the human rights world are experiencing in Southeast Asia. First of all, to place this into context, the institution that's comparable to ASEAN is called the OAS, Organization of American States. The OAS, like ASEAN, for many years didn't have a charter. It wasn't a permanent body. It was a loose confederation of member states that would come together periodically in international meetings and discuss things of mutual concern. However, the OAS, which has antecedents that go back to 1889, wasn't formally established until 1948 with the adoption of the Charter of the Organization of American States. At the same time, in 1948, the then 21 member states of the OAS adopted what's known as the American Declaration of the Rights and Duties of Man. And this is the first human rights instrument in the Inter-American system. And it's still a very important document, and I'll explain a little later on why. So, the first date to keep in mind is 1948. Much like ASEAN, the Organization of American States is a forum where mostly Latin American countries, but also the United States, Canada, can send representatives, the headquarters is in Washington, D.C., and discuss matters of mutual concern, including human rights. An organization that started with 21 countries now has 35 member states. The reason for the increase was that in the 1960s, a number of former British colonies in the West Indies, such as Jamaica, Trinidad and Tobago, Barbados, gained their independence, joined the United Nations, and also joined the Organization of American States. So now we have 35 countries in the OAS. In addition to the Declaration, the American Declaration, both of these, and the Charter of the OAS, I should note that this declaration did not establish a Human Rights Commission or a Human Rights Court. So in 1948, you had the OAS adopting a declaration which essentially was a statement of aspirations. And it's interesting because it's not only a declaration of rights, but of duties. For example, the duty of citizens to pay taxes, or the duty of a citizen to participate in the democratic processes of its country, to vote, to take care of your children. All of these are duties that are contained in this declaration. The declaration also is a mishmash of political and civil rights, such as the right to free speech, religion, transit, and the like, with economic, social, and cultural rights, such as the right to a fair salary, to leisure time, to housing, and so forth. So it's a very interesting document, and I commend it to you. And by the way, you can have access to the documents that I'm going to mention today at the OAS website, which is simply oas.org. And you can go on and see the declaration. But here we are back in 1948, and with no commission and no court. It wasn't until 1959 that the member states of the Organization of American States decided to establish a commission. Not a court, just a commission. At the time, there were a number of problems in the hemisphere, in the Western Hemisphere. One was the Cuban Revolution. Another was a dictatorship in the Dominican Republic, where a man named Rafael Trujillo was really committing human rights violations that were beyond the pale, such as kidnapping and assassinating political enemies outside of the Dominican Republic, one in New York in particular. So, in 1959, the member states decided to establish a commission. This is called the Inter-American Commission of Human Rights. Commission. What is this commission? Well, it's 7 jurists. Oh no, excuse me. There needn't necessarily be lawyers, although mostly they have been lawyers, who are elected for 4-year terms, can be re-elected once, serve in their individual capacity. They are not representatives of their own countries or any other particular countries, but their duty is to defend human rights, protect human rights throughout the Americas, throughout in each and every one of the member states of the Organization of American States. It's curious that during this period, this is really the height of the Cold War, and it was, as I mentioned, the Cuban Revolution which alarmed the West, that this revolution might spread throughout Latin America, given the extreme poverty that exists in a number of member states of the OAS. It's also a period when most of the member states of the OAS were governed by military dictatorships. It's curious that right-wing military dictatorships agreed to establish a Human Rights Commission, which almost inevitably would be critical of these very regimes because they're so often resorted to human rights violations to maintain their political control. When the commission was first established, it didn't even have the power to receive communications. You know, in international human rights law, we use the word communication as it's a euphemism. It really means a complaint, a denunciation. And so in 1959, when this commission was set up, it had no authority, it had no faculty for receiving and processing communications. Not only that, there was no human rights treaty in the inter-American system at that time. The treaty would not come until sometime later. Let's see, put it down here, 1978. But in this interval, there are several important things that took place. One is that in 1965, finally, the Inter-American Commission was expressly given the authority to receive and process communications. So that was an advancement. It was a development. And this provided the Commission with a tool, one of the tools that I'm going to discuss, which it could use in its efforts to defend human rights. It was in 1967 that the member states of the OAS drafted a treaty, the American Convention on Human Rights. And by the way, when I say American, I'm not referring to the United States. I'm referring to the Americas. The American Convention on Human Rights, a multilateral human rights treaty, was first written in 1967, but it took until 1978 to enter into force, because according to the convention, it was necessary that it be ratified by 11 member states, and only upon the deposit of the instrument of ratification of the 11th member state, which was Grenada, by the way, did the treaty enter into force. And that took place in 1978. So it took 11 years from the drafting to the entry into force. So you can see that over time, the human rights instruments and bodies and entities and tools are beginning to emerge. It's a gradual process. It's frustrating. It's not ideal. Ideally, you would have had a treaty right from the beginning. Ideally, you would have a treaty which all the member states are a party. In 1978, there were only 11 member states that were a party to this treaty. As a matter of fact, today, this treaty has only been ratified by 24 of the OAS's 35 member states. That means that there are 11 countries, 11 member states, that have yet to ratify the American Convention. So you really have a dual system. You have one group of countries, 24, that have voluntarily agreed, have accepted the terms of this treaty, and another 11 that have said no. And to make things even more complicated, this treaty establishes the Inter-American Court of Human Rights. It's at this point that you have not merely a commission, but you also have a court. However, ratifying the American Convention on Human Rights, while it creates the court, it doesn't subject the ratifying state to the jurisdiction of that court unless the ratifying state, by separate instrument, by separate writing, agrees to subject itself to the compulsory jurisdiction of the court. And wouldn't you know it, of the 24 that have ratified the convention, only 22 have agreed to be subject to the competence, the jurisdiction of the Inter-American Court of Human Rights. So not all the member states of the OAS can be sued before the Inter-American Court. Only 22 can. So you have a schizophrenic system, if you will. And to make matters worse, of the 24 member states, all of the Spanish-speaking countries, which is the majority, plus Brazil, which is a Portuguese-speaking country, have ratified. And several of the English-speaking Caribbean islands have ratified the convention. But which states have yet to ratify? I'm ashamed to tell you that one of them is the United States. Another is Canada. And the rest are several small West Indian, Caribbean island states. And it's a rather long story why the United States hasn't ratified, and maybe in the question and answer period in several days we can delve into that a little bit. But that's the reality. And it's curious, it's paradoxical really, that this treaty, which entered into force in 1978, in great measure owes its existence to the administration of President Jimmy Carter. Jimmy Carter was President of the United States between 1976 and 1980. And his State Department applied a great deal of pressure in Latin America, particularly in Central America, to encourage the ratification of this treaty. And ironically, many dictatorial regimes actually ratified the treaty, subject to the urging of the United States. So it's ironic that the United States then did not itself ratify the American Convention. It hypocritically, you might argue, prescribed this medicine for other member states of the Organization of American States, but when it came time to step up and embrace and endorse this treaty itself, it didn't do so, and hasn't done so. And here we are in 2012, and the United States has yet to ratify the American Convention on Human Rights, much less accept the jurisdiction of the Inter-American Court of Human Rights. Okay. The Commission is, as I mentioned, composed of 7 individuals. It was only maybe 10, 12 years ago that the first woman was elected to serve on the Commission. By the way, one big difference between Inter-American Commissioners and ASEAN Commissioners is that the Inter-American Commissioners are nominated by their respective governments, but then subject to a what you call it, secret ballot of the OAS General Assembly, that is, a meeting of foreign ministers, the annual meeting of the foreign ministers. And majority wins, becomes member of the Commission. Whereas in ASEAN, each member state appoints its own member of the ASEAN Intergovernmental Human Rights Commission to serve as a representative of the state of that individual's nationality. Okay, what does the Commission do? The Commission is supposed to monitor the state of human rights in the 35 member states of the organization, and it has certain faculties. For instance, I've mentioned one. It can process individual communications. It can receive denunciations, claims of alleged human rights violations. What are the human rights that are to be protected? Those can be found in the American Convention. The American Convention, virtually each article deals with a different human right. Freedom of expression, freedom of thought, freedom of assembly, freedom of association, and so forth. But that only pertains to 24 countries. What about the other 11 countries? That's why we refer back to the American Declaration of the Rights and Duties of Man. The other 11 countries, the United States, Canada, and so forth, are subject to what we now, by and large, consider customary international law, as expressed in the American Declaration of the Rights and Duties of Man. Again, a bifurcation, a separation of 2 groups of countries. The Commission can hold hearings. It can engage in fact-finding. In other words, when it receives a complaint, it seeks to verify that complaint, to determine whether it's true or not, whether the claims set forth, whether there's evidence. The Commission can hold hearings in Washington or in member states It can receive affidavits. It can receive forensic evidence. It can have adversarial hearings in which representatives of member states can be present. Lawyers, ambassadors, other diplomats, to defend the state, to bring in their own witnesses. So these hearings are valuable fact-finding tools. Another fact-finding measure, tool available to this commission, and this goes back to Naomi's question: what does the system need in order to be of some utility? The Inter-American Commission can and has conducted numerous on-site human rights investigations. How does that work? Well, the Commission seeks authorization from a government to visit the government under certain conditions. That the Commission will be free to travel within the member state, to speak in private with whomever it pleases, to respect the security and confidentiality of those communications, to protect witnesses who come forth to cooperate with the Commission. These are parts of the understanding between the Commission and the government that's under investigation. And the Commission has, and during my 27 years with the Inter-American Commission on Human Rights, I participated in scores of these kinds of on-site investigations. I helped organize quite a number. I participated in them and the like. And throughout the Americas, including the United States and Canada, by the way, and numerous countries in Central and South America. I've been to Chile and Peru and Ecuador and Bolivia and on, Brazil. And in the Caribbean, Dominican Republic, Haiti. So, on-site human rights investigations are very important for if you're going to have not only a commission that really genuinely seeks the truth and tells the truth, but is seen to do so. Doesn't sit at its headquarters in Jakarta or in Washington, D.C. and passively issue pronouncements occasionally and so on. No, it must be proactive. In order to do that, it's important to bear in mind that this commission, as well as the judges on the court, and I'm going to talk a bit more about the court in a minute, but these are part-time people. One of the most important ingredients in an effective human rights system is a competent, dedicated secretarial staff. Without a good executive, permanent, full-time, and a staff, and a decent budget, and the capacity to travel and so forth, this enterprise will be a flop, will fail. It's essential that you have a good secretary. It's the secretariat that physically receives the denunciations, that processes them, that sends letters to foreign ministries, that makes inquiries, that coordinates hearings. By the way, the hearings of the Inter-American Commission nowadays are webcast. By and large, they're public, unless the parties insist otherwise. But the practice nowadays is to webcast hearings, and they're like very similar to common law courts. So that means that a journalist in Buenos Aires can observe a hearing which takes place in Washington, D.C., without having to travel to the United States. And he can report accordingly. So you know that in the field of human rights, transparency, the marshaling of shame, is still essentially what we're engaged in. We're shedding light on disgraceful conduct committed by some human beings against others. let's talk a bit about the court, and then I want to talk about go back to the question of tools. And maybe I'll just bear with me for another 5 or 10 minutes and we'll finish. The American Convention on Human Rights establishes a court. That court is composed of 7 judges who are, again, are nominated by the member states of these 24 countries. All of the states parties to the convention are at liberty to nominate candidates for the court. And then at the General Assembly of the OAS, an election takes place, a secret vote, secret ballot, and 7 judges are elected. They serve for 6 years, and they can be re-elected once. So you could have a judge sit for a total of 12 years if he's re-elected. Again, nowadays there are more women on the court, more women on the commission than was the custom in the past. I think this is a healthy development. As far as I know, on the ASEAN Commission, correct me if I'm wrong, but I believe that they're all men. We'll see over time whether that situation continues. I may be mistaken. If I am, I apologize. But so this court, which normally meets 2 or 3 times a year, has its headquarters in San Jose, Costa Rica. And they have a secretariat staff too, quite competent. There's a young fellow named Pablo Saavedra, who is the registrar of the court. He's the boss. He's the executive who manages the day-to-day affairs of the court. The judges on the court, who are of different nationalities, never 2 of the same nationality, the same goes for the members of the commission, come together to try cases that are brought by individuals, by activists, by attorneys, on behalf of victims. Victims can act pro se on their own behalf, or they can, more often, they're represented by non-governmental organizations, CSOs, civil society organizations, and that's where people like you and me come into the picture. Now that I no longer work for the Inter-American Commission on Human Rights, I have brought cases against governments in the inter-American system on behalf of victims, and I've litigated cases before the Inter-American Commission and the Inter-American Court. By the way, I've also brought cases to the African Commission on Human and People's Rights on behalf of a former student of mine. They have similar procedures. In any event, what's the difference between a commission and a court? Well, a commission is a quasi-judicial body. It's more flexible. It engages in mediation, trying to settle cases. The objective isn't to try every case. The objective is to get justice and to get truth. So that may mean out-of-court settlements. The commission can be more proactive in conducting on-site visits and the like. The commission has rapporteurs. Individuals, 2 types of rapporteurs. With one exception, the rapporteurs are members of the commission. So the 7 members of the commission divide up the countries amongst themselves and serve as country rapporteurs. So there will be a country rapporteur for the United States, country rapporteur for El Salvador, a country rapporteur for Panama, and so on. With only 7 members of the commission, obviously each commissioner has to take on a number of countries. And in doing so, they take into account the linguistic abilities of the members. If it's a French-speaking member, he or she might be rapporteur, for example, for Haiti or for Canada. Canada is a bilingual country, English, French. So you have country rapporteurs. The second kind of rapporteurship is thematic rapporteurs. So a member of the Inter-American Commission on Human Rights might serve as rapporteur on the rights of women, rapporteur on the rights of the child, rapporteur on the rights of indigenous people. To have a good human rights system, You need a good treaty, ideally, that creates bodies of people of real integrity and methods for their selection. I think that the existence of a commission and court makes good sense. The commission processes cases, presents them to the court. Nowadays, it's the NGOs and the CSOs that actually litigate the cases before the court. The commission brings the cases, but the CSOs argue them. I haven't mentioned yet special measures that both the commission and the court can issue in emergency situations. They're similar to injunctions. They're called precautionary measures and provisional measures. The commission issues precautionary measures, the court provisional measures. In the case of the court, they're equivalent of an injunction or a mandamus. So I really don't have time to go into them, but these are the tools, investigating on the ground, multilingual, capable staff, decent budget. These are essential to have a good system. The other thing I want to emphasize is you can see that the Inter-American system developed over time. This is not something that happens overnight. We have to have patience and persistence. And this is going to be true in ASEAN and in many other regions of the world. And only now have they created an African court, for instance. But the commission existed since the 1980s. So these developments take place when the political circumstances allow them. We in the human rights community have to know when and how we can take advantage of these openings to press for the construction of solid human rights bodies that can supplement domestic law and try to assure greater respect for human rights throughout our various regions of the world, whether it be the Americas or whether it be Southeast Asia. Thank you.